The conference room smelled like old paper, and central heating turned up too high. It was a Tuesday in November, 10:47 a.m., and the light coming through the blinds was the flat, gray kind that makes everything look like it has already been decided. I was sitting at a rectangular table across from my parents. My father, Dennis, had his hands folded on the table the way he always did when he was performing Patience. My mother, Carol, was wearing the pearl earrings she reserved for occasions she considered important. Between them sat their attorney, a man named Philip Greer, who had represented my parents for 11 years, and who had the careful blankness of someone paid to have no opinions. My name is Meg. I am 34 years old. I am a single mother to a boy named Owen, who is 8, and for the past 3 years I have been the only person in my family who visited my grandfather more than twice a year. My grandfather, Walter, was 81. He had been moved 6 weeks before this meeting to a county-assisted care facility 14 miles from the house he had owned for 43 years, the house he had signed over to my parents. The house my parents had sold in September for $890,000. Philip Greer opened the folder in front of him and began to read. The estate, after the sale of the property and the liquidation of Walter's investment accounts, totaled approximately $1.24 million. My parents had been named as primary beneficiaries of a trust document dated 3 years ago, executed during what Philip described as a period of estate planning. I looked at my father. Dennis looked at the table. Then Philip said the part that made the room go very still. He said that Walter had attempted to amend the trust 14 months ago. He said the amendment had been filed, and then he said that the amendment had been subsequently contested and voided on the grounds of cognitive incapacity. I said, "Who contested it?" Philip looked at my father. My father said nothing. I said, "Who filed the incapacity claim?" And my mother touched her pearl earring and looked out the window and said, "We did what was best for him, Meg. You weren't there. You don't understand how hard it was." I need to stop here for just a moment. Before I tell you what was in that amendment, what Walter had tried to change, what my parents had spent 14 months and a contested legal filing to prevent, I want to ask you something first. Where in the world are you right now? What does it look like outside? Is it morning or evening where you are? And are you somewhere quiet or somewhere full of noise? And I want to ask you this. Have you ever watched someone you love be slowly moved off the map by the people who were supposed to protect them? I think this story is going to reach people who need it. But before I tell you what happened next, let me take you back to how this started. I grew up in a suburb of Richmond, Virginia, in a house with a large oak tree in the front yard and a family that looked from the outside like most families look from the outside. My father, Dennis, was a commercial real estate broker, well-dressed, well-spoken, the kind of man who remembered names at parties and made people feel seen in ways that were entirely strategic. My mother, Carol, taught elementary school for 22 years and had the community trust that profession tends to generate. They were, in the language of their social world, good people, responsible, solid. My grandfather, Walter, was my mother's father. He had been a civil engineer, retired at 67, widowed at 73 when my grandmother, Ruth, died of a stroke. He lived in a craftsman house in Henrico County with a garden he tended with the same precision he had once applied to load-bearing calculations. He grew tomatoes and dahlias. He kept a notebook of bird sightings. He made his own bread on Sunday mornings. When I was 29, 2 years after my divorce from Owen's father, I started visiting Walter on Thursday afternoons. He was 78 then, still sharp, still making bread. We would sit at his kitchen table and he would tell me stories about the bridges he had designed, and I would tell him about Owen's soccer games and the freelance accounting work I was doing from my apartment. It was the quietest, most honest relationship in my life. My parents visited Walter on holidays, sometimes Easter, reliably Christmas. Carol called him on Sundays, briefly, and would report to the family group chat that "Dad sounds good," with the efficiency of someone completing a task. What I watched over several years was this. The first time my parents suggested Walter think about his options regarding the house, Walter was 79 and had just had a minor fall in the garden. He had not been seriously hurt. He told me about the conversation the following Thursday with a look I had not seen on his face before. Not fear exactly, but a kind of watchfulness. He said Dennis had mentioned a trust structure for tax purposes. Walter said he had told Dennis he would think about it. 6 months later, the trust was signed. I did not find out until a year after that. When I asked my mother about it, she said, "Your grandfather wanted to make sure everything was handled properly. Dennis knows these things." She said it with the finality she used for topics she considered closed. The second time I noticed something wrong, Walter called me in February of the following year, on a Thursday when I had not been able to visit, and told me he had asked his bank about withdrawing $40,000 from his savings account. He said the bank had told him the account required a co-signatory approval for withdrawals over $5,000. He said he had not known that. He said Dennis had arranged it for protection. I asked Walter if he had agreed to that arrangement. He was quiet for a moment. Then he said, "I signed a lot of papers, Maggie. I didn't read all of them." I made a note in my phone. I did not yet know what to do with it. The third thing, at Christmas that year, Walter mentioned at dinner that he had been writing letters to an old engineering colleague in Portland, a man named Arthur Finch, who had been Walter's closest friend for 40 years. Walter said Arthur had invited him to visit for 2 weeks in the spring. Dennis said, lightly, that the trip sounded ambitious for someone his age and that they would need to think carefully about the logistics. Walter did not mention the trip again. I knew Arthur Finch by name only. I had no way of knowing at that Christmas dinner that Arthur had been quietly documenting things about my grandfather's situation for over a year, that he and Walter had been corresponding in letters, paper letters specifically, because Walter had told Arthur he believed his email was being monitored, and that Arthur had already consulted an elder law attorney in Portland named Diane Reyes. I did not know any of that yet. What I knew was that Walter's Thursday bread had started to taste different. He was measuring wrong, he said. He kept forgetting the salt. The first level arrived in March. Dennis called me, not Carol, Dennis, which was already unusual, and said that Walter's doctor had expressed concern about his cognitive function and that the family was exploring options for his care. He said this with the careful tone of a man delivering a real estate summary, organized, unemotional, pre-concluded. He said they were looking at memory care facilities. I said, "Which doctor?" Dennis said, "Dr. Halverson." I knew Dr. Halverson's name. Walter had mentioned him. But Walter had also told me 3 weeks prior that he found Halverson dismissive and had asked me to help him research switching to a different practice. I said, "Walter hasn't mentioned any cognitive concerns to me." Dennis said, "Meg, you see him once a week for coffee. We're managing his full situation." I said nothing. I hung up. Level 2 came 2 weeks later through Carol. She called me on a Sunday in her gentlest register and said that the family had made a decision about Walter's living situation and that they hoped I would be supportive. She said Walter had agreed to move into a care community. She said it would be better for everyone. She said it with such practiced warmth that disagreement felt like cruelty. I asked if I could speak with Walter directly about this. Carol said, "Of course, sweetheart, he knows." I called Walter that afternoon. He did not sound like someone who knew. He sounded like someone who had been told. Level 3, I arrived at Walter's house the following Thursday to find 2 women I did not recognize packing boxes in the living room. Dennis had hired an estate clearance company. Walter was sitting in his armchair watching his 43 years being sorted into categories. His bird notebook was in a box labeled Donate. I took the notebook out of the box. I held it. Dennis arrived 20 minutes later and said in front of the clearance workers that I was making this harder than it needed to be and that my emotional attachment to objects was not helpful. He said it the way he said most things, pleasantly, as though he was doing me a favor by being honest. I put the notebook in my bag. I said nothing. Level 4 happened at the care facility 2 months after Walter moved in. I arrived for a Thursday visit and was told by the front desk that my visitation had been flagged as requiring prior approval, per a request from Walter's primary family contacts, Dennis and Carol. The facility coordinator, a woman named Sandra, looked genuinely uncomfortable delivering this information. She said the request had been filed 6 days after Walter's admission. I stood at that front desk for a long moment. Then I said, "Is my grandfather aware that I've been coming every week?" Sandra said, "I honestly don't know, ma'am." I drove home. I sat in my car in my apartment parking lot for 22 minutes. Then I called a number I had looked up 3 days earlier, when something in me had begun to understand that looking things up quietly was something I needed to start doing. Level 5, 6 weeks after the visitation restriction, Walter called me from a borrowed phone. A nurse named Terry had let him use hers. He said he had tried to reach me, and his calls were not going through. He said he wanted me to know that he had tried to change his trust. He said he had gone to a notary himself, that a neighbor had driven him, that he had filed an amendment. He said Dennis had found out and had handled it. His voice was steady. He was 81, and his voice was completely steady. He said, "Maggie, I wrote everything down. I sent it to Arthur. Arthur has all of it." I said, "I know, Grandpa. I'm going to fix this." He said, "I know you are." Level 6 came from Dennis. He called me the day after Walter's call. I do not know how he knew we had spoken, but he knew, and his voice had shed every layer of real estate pleasantness. He said that I had been interfering in a family matter, and that if I continued to involve myself, he would take steps to formalize my exclusion from all decisions related to Walter's care. Then he said it, clearly, without hesitation. He said, "Your grandfather is an old man with declining cognition and no legal standing. The trust is settled. The house is sold. There is nothing left for him to find and nothing left for him to give you. Nothing left for him to give you." I wrote it down word for word. "Okay," I said. "Good," Dennis said. I pressed end. That evening, Owen asked me to help him with a school project. He was building a model bridge from popsicle sticks. It was a unit on engineering, and he was frustrated because one of the supports kept collapsing. We sat on the kitchen floor together for an hour rebuilding it, and at some point he looked up at me and said, "Mom, why do bridges need foundations?" I looked at him. He said, "Why can't they just balance?" I said, "Because without a foundation, the weight destroys everything eventually." He nodded seriously, the way 8-year-olds nod when they are filing something away. Then he said, "Is Great-Grandpa Walter okay? We haven't seen him in a while." I had spent 3 years watching my parents dismantle Walter's life one signed document at a time, telling myself that confrontation would make things worse, that there was a version of this where everyone came out intact. In that moment, I stopped. I looked at my son's popsicle bridge, and I thought about Walter's bird notebook and the letters sent to Portland on paper because he feared his email was being read. and I thought about the word foundation, and I thought, the only thing I have been protecting is their comfort. I got up from the kitchen floor, went to my desk, and opened my laptop. I typed one email to Diane Reyes, the elder law attorney in Portland, whose name Arthur Finch had given me 3 weeks before. The subject line said, "I have documentation. I am ready." Diane Reyes called me the following morning at 8:15 a.m. She had a direct, unhurried manner, and she asked me questions in a specific order that told me she had done this before. She asked about the trust signing date, the co-signatory bank arrangement, the visitation restriction, the contested amendment, and the timeline of the house sale. I answered each question from the notes I'd been keeping for 2 years in a password-protected document I had titled with some private precision, Thursdays. Then she said, "Arthur Finch has provided me with 41 letters from your grandfather, spanning the last 26 months. Your grandfather documented every significant financial and personal decision during that period, in his own hand, with dates. He also documented conversations with your parents and with his attorney that differ substantially from the official record." I said, "What does that mean legally?" She said, "It means the incapacity claim used to void his trust amendment may have been fabricated or significantly overstated. It means the trust signing itself may be contestable on grounds of undue influence, and it means we have a paper trail that the other side does not know exists." She said the word fabricated the way engineers say words, precisely, without drama, because the precision was the point. I retained Diane Reyes that afternoon. Her retainer was $8,500. I paid it from my savings and did not tell anyone. Diane contacted Dr. Halverson's practice and requested Walter's complete cognitive assessment records. The records arrived within 10 days, and what they showed was this. The assessment used to support the incapacity claim had been conducted at a single appointment, without standard multi-session protocol, by a physician who had seen Walter exactly twice. The assessment had been requested and scheduled by Dennis. A second opinion assessment, arranged by Diane through an independent neurologist named Dr. Patricia Osai, was conducted over 3 sessions. Dr. Osai's finding, Walter showed mild age-related memory variation, with no clinical indicators of decision-making incapacity at the time of the trust amendment. The amendment, which Walter had attempted to file 14 months ago, named me as co-trustee, and redirected $380,000 of the estate to a separate protected account for Walter's personal care expenses that my parents had been drawing from the trust without itemized accounting. Diane Reyes filed a petition to contest the trust on grounds of undue influence and fraudulent incapacity representation. She filed a simultaneous complaint with the Virginia Department for Aging and Rehabilitative Services, citing financial exploitation of a vulnerable adult. Dennis called me 4 hours after the filings were served. His voice had a quality I had never heard in it, not anger, something thinner. He said that I was destroying the family over money I was never entitled to, that Walter wanted this arrangement, that I was twisting an old man's words to serve my own interests. I said, "Diane Reyes will be in touch with Philip Greer." He said, "If you go through with this, you will never be part of this family." I said, "I'm not doing this to be part of this family." Silence. Then he hung up. The hearing was on a Thursday, which felt to me like something Walter would have appreciated. It was held in a Richmond probate courtroom, plain and fluorescent, smelling faintly of floor cleaner and old wood. Dennis and Carol arrived with Philip Greer. My parents looked composed in the way people look composed when they have rehearsed it. Carol was wearing the pearl earrings again. Diane presented the case in the order she had always described, methodically, without theater. First, Arthur Finch. He appeared via video from Portland, 83 years old, white-haired, sitting at a desk with a stack of envelopes beside him. He described the correspondence with Walter. He read, with the court's permission, 3 selected passages from Walter's letters, Walter's own words in his own handwriting, describing the pressure applied to sign the trust, the confusion over the bank arrangements, and the specific conversation in which Dennis had told him that the family would be better protected if Walter signed without consulting outside counsel. Philip Greer objected twice. Both objections were overruled. Then Dr. Osai presented her assessment findings and contrasted them with the single-session evaluation used to void the amendment. She used clinical language throughout, and her conclusion was stated without embellishment. The original incapacity determination did not meet professional standard of care and would not withstand peer review. Dennis leaned over to Philip Greer and said something I could not hear. Then Diane presented the financial accounting. The trust had received $1.24 million. Walter's documented care expenses at the facility totaled $87,000 over 18 months. The remaining disbursements, $340,000 drawn from the trust in the prior 2 years, had no itemized care documentation. The house sale proceeds of $890,000 had been transferred directly to Dennis and Carol's joint account within 11 days of closing. The judge asked Dennis directly whether Walter had received independent legal counsel before signing the original trust. Dennis said he had access to counsel. The judge said, "Did he use it?" Dennis said he chose not to. Carol touched her pearl earring and looked at the floor. The judge said nothing for a long moment. Then she spoke. She set aside the voided amendment and reinstated it. She ordered an independent fiduciary appointed to audit all trust disbursements. She referred the matter to the Virginia Attorney General's office for review under the Adult Protective Services Act. She ordered the $340,000 in undocumented disbursements frozen pending the audit. Dennis stood up and said, "This is not what Walter wanted." The judge looked at him and said, "Sir, sit down." He sat down. I said nothing. The audit concluded 4 months later. The independent fiduciary found $312,000 in disbursements with no legitimate care documentation. The Virginia AG's office filed civil charges of financial exploitation of a vulnerable adult against both Dennis and Carol. The charges carried a restitution requirement of $312,000 plus interest and a civil penalty of $45,000. Dennis and Carol's joint assets were partially liened pending resolution. Philip Greer withdrew from representing them. Dennis lost 2 significant commercial real estate clients when the charges became part of the public court record, as they are in Virginia. His firm placed him on administrative leave. He resigned the following month. Walter was moved, with the reinstated trust funds directed to his care, to a facility 8 minutes from my apartment. It had a garden. On the first Thursday I visited him there, he was sitting by a window with a new notebook. I had bought him one, small and green, and he was watching a bird feeder someone had hung outside. He looked up when I came in. He said, "You're late." I said, "I know, traffic." He said, "Sit down. I've been keeping a list." I sat down. He showed me the notebook. He had written the date at the top and below it, Chickadee, 9:04 a.m., Sparrow, 9:31 a.m., Cardinal, 10:15 a.m. I stayed for 2 hours. Dennis sent me an email in January. It was long, and it contained the word sorry many times, and it contained the phrase, "I hope you can understand the pressure we were under," and it contained a request to speak. I read it once. I moved it to a folder I labeled Received. I did not reply. Owen came with me to visit Walter the following Thursday. They played chess. Owen lost badly and did not mind. On the drive home, he said, "Great-Grandpa Walter is really smart." I said, "Yes, he is." He said, "Can we come next week?" "Yes," I said, "every Thursday." What I know now that I spent too long not knowing, caring for someone and controlling someone are not the same act, and the people who confuse them, intentionally or otherwise, will always call the difference ingratitude. Walter had built a life with precision and care and quiet love. The people entrusted with protecting that life had treated it as inventory, and the only thing that stopped them from completing what they had started was 41 paper letters sent to Portland and one Thursday afternoon when my son asked me why bridges need foundations. The foundation was always Walter. I just finally stopped letting them tell me otherwise. So, if you were in my place, what would you have done? Would you have done what I did and spent your savings on an attorney and your family's approval on the truth? Or would you have kept the peace, kept your seat at the table, and kept telling yourself that staying quiet was the same thing as being kind? I genuinely want to know.